Test, test. Test, test, test.
Usually people, when you're not that long, start getting less. They realize
Test.
That, yeah.
Yeah, so I'm really just people. For the room, you kind of have to be really close if
Yeah.
you wanted to come out of speakers.
Yeah.
For the
YouTube, they want you to,
YouTube, you
they
have
want
to
to
be.
filter it. And
Test,
so,
test.
We'll call back to order the meeting of the Water Quality Control Commission, and I'll turn the gavel over to Kevin Greer, who's going to be the hearing chair for Reg 61.
Okay, if I missed something, just tell me, but we're here in the Florence Sabin Conference Room at the Colorado Department of Public Health and Environment. And this rulemaking hearing is for consideration of the adoption of revisions to the Colorado Discharge Permit System Regulations, Regulation number 61. Commissioners present: Mike Gusev, Troy Waters, Fred Menzer, Joan Card, Rick Hum, David Baumgarten, I guess. Barb.
Yeah, just technically for the record, I guess we'd say Commissioner Baumgarten's not present in the room at this time, but we expect him to be present for the hearing.
Okay. Barbara Biggs and myself, Kevin Greer. The pre-hearing conference was held on Tuesday, September 25th, and the pre-hearing order summarizes the actions taken. We'll go through a few of those things here. We'll start with disclosures and recusals. Commissioner Clary is not here, so we'll leave hers out, but Commissioner Biggs is the general manager of the Roxborough Water and Sanitation District, which has entered into a joint operating agreement with Dominion Water and Sanitation District that includes the future operation of the Chatfield Basin Water Reclamation Facility as Dominion's contract operator. Commissioner Biggs believes this contractual relationship is unrelated to the matters to be considered in this rulemaking, and she believes she can participate impartially. Roxborough Water and Sanitation District also has an intergovernmental agreement with the city of Littleton to convey and treat Roxborough's wastewater at the South Platte Water Renewal Partners facility owned by the cities of Inglewood and Littleton. Commissioner Biggs believes that this contractual relationship is unrelated to the matters to be considered in this rulemaking and believes she can participate impartially. No objections were raised at the pre-hearing conference. I guess, does anybody have any concerns or questions about disclosures? Okay, so for the presentation and times, we're going to start with the division. You'll have 35 minutes, followed by the joint stakeholders, which also includes Miller Coors. They were separate in their submissions, but we'll speak together and have 30 minutes. AFCURE will have 5 minutes. Then we'll do a public comment, and then the division will wrap up with 10 minutes. Just a reminder that for public comment, there is a sign-up sheet over by the door on the side of the room. If you'd like to sign up, please do so at any time in the next half hour, I guess. In addition, just to clarify a few things, cross-examination is acceptable. However, it will take away from your party's time and will occur following commissioner questions. Let's see. Just another note, that after each party's testimony, we'll go through question and answer with the commission. Then if there's any cross-examination, we'll do it at that time. Following all of the parties talking, we will deliberate and I guess close the hearing ideally. But if you have any documents that we have not seen yet, please tell us that when you come up to the table. And then also please state your name, who you're with, and swear to tell the truth. So I think that's it. All right, so division.
Thank you, Hearing Chair Greer and Commissioners. Good afternoon. My name is Ellen Howard-Kutzer. I'm the Clean Water Section Permits Manager with the division. With me here is Meg Parrish, who you already heard from this morning, Unit 1 Manager, and Annette Quill, Senior Assistant Attorney General. So just before I get into this, I want to be sure, we did have a late submission on Friday. I believe Tricia may have emailed that to you. I did bring hard copies as well. It's Division Exhibit 5, so everybody's got a copy of that, correct? Excellent.
Yes.
Oh, Jerry needs one. Okay. Oh, that's right. Swearing to tell the truth. I know. It's hard to change roles, Jerry, you know. I do swear to tell the truth today. So we've taken care of Exhibit 5. I'll ask you to have this handy when we get into a couple of items. And I'm going to do my best with the tech here. I think the clicker might not be working exactly, but we'll give it a shot. So, and it's not. Sorry, can you do the next slide? All righty. So today we're here to discuss certain proposed changes to Regulation 61, which is the Colorado Discharge Permit System Regulation, or the permitting regulations. Broadly, these are the regulatory requirements that the division has to follow when it issues permits for allowable discharges to state waters. Today, we're only proposing a few changes to these regulations. Specifically, these are implementing changes that have been required by recent EPA rule changes at a federal level. This includes inclusion of a requirement to use sufficiently sensitive test methods or laboratory detection techniques, and a requirement for permittees to abide by the electronic reporting rule. Secondly, we're implementing the agricultural waste exemption to the permitting regulations, which was enacted by the Colorado legislature. And then finally, we're proposing to make some changes to the procedural requirements for permit issuance, including both a clarification of the reopening of the public comment process, establishing a new responsive comment period. Uh-oh. That's okay, we'll take a quick pause. It helps we're still on slide 2. So one more. Oh, that's okay. And I've had, just real fast before we get going, I've had good luck with just the arrows. I don't know if that's what, but okay. Sorry for the tech. Okay. And then finally, we're clarifying some requirements to identify issues of concern during the public comment period before an administrative appeal of a permit's filed. So I just want to warn everybody, I know it's after lunch. We're here today to talk about some pretty specific legal language. I think for the attorneys among us, that might be exciting. It's probably not exciting for everybody else. So I'm going to do my best to keep this light and keep things moving to the best of my ability. Next slide. So before we dive into that exciting legal language, I just want to put forward a few of the policy considerations behind these changes. First and foremost, while this is an EPA requirement, the changes to requiring sufficiently sensitive test methods will ensure that the data that's collected under a permit will use the proper laboratory analysis techniques, which in turn gives us at the division the best information available to make future permitting and watershed decisions. Secondly, an inclusion of a firm requirement in Regulation 61 to use the electronic reporting system will, we believe, increase Colorado's adoption rate to comply with the e-reporting rule. Right now, we're hovering at about 54%, so we need to make some big strides to improve. Third, the changes to Section 61.5 regarding the reopening of the public comment period and establishing the responsive comment period will offer more opportunities for public comment and engagement. And then finally, clarifying those existing requirements for identifying issues during the public comment period will ensure that everybody is on the same page, both the division, permittees, and members of the public, to understand what the expectations are before a permit appeal is filed, and to give the division an increased opportunity to respond to identified issues if it's appropriate. This, we believe, will increase efficiency and will preserve division resources when an appeal occurs. Next slide. So So before we dig into the issues and the remaining items of concern, I'll give you a little bit of background about both why you're here to discuss this today and where we've come since our rebuttal proposal. Next slide. So as we know, here in Colorado, the commission doesn't get involved in either the issuance of permits or permit appeals. So you may be asking yourself, isn't it a bit strange for the commission to be making a decision about the permitting regulations? While that might be the case, I do think that the commission's role here today is really important. First of all, you're here to make sure that the regulations ensure a fair process for both the division staff, the permittees, and members of the public as a whole. You also have the ability to adopt regulations that increase the transparency of our permitting process with the public. The responsive comment period that we're proposing here today that was originally Exhibit 4. You'll see that these modifications are captured in 61.5 sub 2, little d, and little e, which are on pages 1 and 2 of Exhibit 5. Secondly, the division and stakeholders were able to resolve issues related to language requiring electronic reporting and use of the NetDMR system. This language is contained in Regulation 61.4D and the associated statement of basis and purpose language, which you can see on the bottom of page 3, 4, and 5 of Exhibit 5. Next slide. So with that, 2 key issues remain. Those related to considerations for extending the color comment period and the use of the term undue delay, and the statement of basis and purpose language explaining the scope of permit adjudicatory hearings. In Exhibit 5, the division has highlighted these areas of disagreement for you. They're on page 1 and on page 5 with some pink highlighter. Next slide. So as you're taking a look at this, you might be asking yourself, wow, this is really just a language fight, and you guys couldn't have worked this out? I'll tell you, we tried very, very hard to do so, I think, on both fronts, the stakeholders and the division. We spent a lot of time with each other in meetings. And the short answer is no. There are a few pretty important concepts that are captured behind the remaining language issues, and the division really feels strongly about these. As hard as we tried, we just weren't able to get 100% of the way here, and that's part of why we're here to ask you today to resolve these remaining issues. So I won't say that we're going so far as arguing about what the definition of is, but there is some meaning behind this remaining language, and we're going to try to explain some of the policy reasons behind that for you here today so you can kind of understand where we're coming from. Next slide. And with that, I'm going to turn it over to Annette to start in and discuss issue 1.
Okay, again, I'm Annette Quill with the Attorney General's Office, and I swear to tell the truth. Okay. So, the first unresolved issue relates to the division's discretion to extend the public comment period for draft permits. Section 61.52D requires a public comment period of 30 days after the date the draft permit is posted for public notice. The division has historically given discretionary extensions of time to comment on draft permits, both to permittees and to members of the public, especially where there's complex issues involved. The new language in this section is intended to make that practice transparent and to clarify that in order to justify an extension, the requester must show the need for the additional time, and the division has to find that granting the additional time won't unduly delay permit issuance. This clarification in the regulation isn't meant to change historic division practice at all. The consequences of delaying permit issuance have always been a factor that the division considers in these situations. And most extensions are given for anywhere from 30 to 60 days, just as a point of reference. But in reality, undue delay of permit issuance as a reason for limiting public comment extensions doesn't occur very frequently, but the division just wants to account for where it might. There are times when the division needs to issue a permit right away, or the permittee needs a permit issued right away. And in these situations, delay could be problematic. So here's a recent example. So EPA recently adopted a new rule for cooling water intake structures, which are intakes that use surface water to cool water for industrial processes like steam-fired power plants. And this rule is meant to ensure that fish aren't getting taken up into the process and sucked up into the system. So under this new EPA rule, different requirements applied to permits issued either before July 14th of 2018 or after July 14th. So permits issued after that date had to have more complex biological studies on hand and incorporated into the permit. But permits issued before that date allowed more flexibility for the division to give permittees more time to collect that data that was necessary. And so there was a big advantage for permittees to get the permits issued before July 14, 2018. So specifically for one of the division's permits in Pueblo for Excel's Comanche Station, the Sierra Club had submitted a request for additional time to file comments. And the division was concerned that in that case, giving the Sierra Club the full amount of extra time that they wanted would impede the division's ability to issue the permit before that July 14th deadline. So in that case, the division gave the Sierra Club a partial extension of time, just over 15 days, because for obvious reasons, it wanted to get the permit out the door and to help both the division and Excel be before that deadline. Next slide, please. So the term undue delay was selected for a couple of reasons. First, undue delay, is a term of art that's used in many different legal contexts, such as contracts, and it's meant to capture an idea of where delay is not appropriate under any given set of circumstances. So it allows the reviewer to assess on a case-by-case basis, essentially. So the concept of undue delay is flexible in that way. It can mean unreasonable, unwarranted, unfair, unnecessary, unacceptable, or inappropriate, depending on the particular situation. It allows flexibility for the division to determine on a case-by-case basis whether granting an extension or the length of the extension would be too much to have unintended consequences. It's not a license for the division to be arbitrary by any means. It instead allows for appropriate balancing of interests where extensions are requested. So, undue delay could include delay that results in harm, either to the permittee or to the division, but it could also include other factors, such as the division's need to issue a permit based on its own workload considerations, for instance, or the need to make a permit modification based on changing conditions. The statement of base and purpose language, which I don't have up on a slide, but which you can find on page 6 of Exhibit 5, about a third of the way down. And this is language that's been agreed to by all of the parties. And we believe that it is helpful in providing a little bit more guidance on what undue delay means. And it says, in exercising its discretion to extend the public comment period, the division may consider whether the public has received a meaningful opportunity to review and comment on a draft permit, and should balance the public's desire for an extended review period against other factors, such as the division's obligation to timely issue or deny a permit application and the potential harm from delay in permit issuance or denial. Next slide, please. So, in conclusion, the division feels strongly that the unduly delay language should be included in the regulation itself for the sake of transparency. The division believes that the alternate joint stakeholder proposal that uses the term harmful delay is unnecessarily limiting. It only looks at one aspect of the statement of base and purpose language, and it creates its own ambiguity problems. The division maintains that the phrase undue delay with the accompanying statement of base and purpose language will best encompass the diversity of potential situations that will be encountered. And so, therefore, the division recommends that the commission adopt its proposal for section 61.5 2D little ia, and this is both in division exhibit 4 and 5. And this will ensure that the division retains the flexibility it needs in the realm of discretionary public comment period extensions.
Can I just interrupt for 1 second? We're having some folks online are having trouble with the sound, and they're saying it's garbled and this is opposite direction of what we used to get with when we streamed through Adobe Connect. We were supposed to be really close to the microphone, but I guess now we're supposed to be far away. So just try that.
That's better.
Sorry. Thank you.
Sorry about that. I'll start off here when we get to the next slide. I just want to clarify that I use the term raise on these next slides, and you'll see in the revised Exhibit 5, we actually agreed to the term identified, so I apologize for that inconsistency here. Sorry, what's that? No, I'm too close? There? Okay. Okay. So getting into the second major issues, really this deals with what scope of what's fair game during a permit adjudicatory appeal and the requirement to identify issues in public comments prior to appealing a permit. Before digging into this, I need to mention that public notice and comment is really a foundational concept in both administrative law generally and under the Clean Water Act. Responding to public comments that we receive at the permit section is a really, really important part of our job, and it's one that we take very seriously. Many issues can be resolved through the public comment process, and we really do this all the time. But we can't properly respond to an item or an issue or consider any changes if the commenters don't tell us what the problems are with the draft permit. So requiring that issues be properly identified during the public comment period is a key part of this process. Unfortunately, it's not something that's been well identified in Regulation 61.7 in the past. So there's a few policy reasons why this is important. I'll go over them briefly in a little detail. Next slide. So to the first point, the requirement to raise issues in public comments prior to raising them in litigation is part of the foundation of the legal doctrine of exhaustion of administrative remedies. For those of us who took administrative law in law school, I probably remember this well. I have on the slide the most simplistic definition I could find. It's still pretty wordy. At its core, basically, this is a requirement that you raise an issue directly with the agency before you actually raise the issue in a court of law during litigation. Next slide. So the current regulatory language in the existing version of 61.7 is a little bit vague when it comes to exhausting your administrative remedies. 61.7 currently states only issues of law or fact raised by the applicant or other person prior to an adjudicatory hearing may be raised at the adjudicatory hearing. That doesn't specify that the issues must be raised in the public notice comments. In practice, the only real forum that exists where issues can be raised to the division is public comments, and that's where we see most of these issues raised. However, this lack of clarity in the regulation has caused some issues in recent permit appeals. In those cases, new issues were continually being raised throughout different parts of a permit appeal, including the briefing process, hearings, and even closing statements. This created a situation where the division had to spend a tremendous amount of its own resources and of its legal resources to continually respond to new issues over and over again, and without having the opportunity to fully address them during the public comment period and potentially resolve those issues if they could be resolved. So the primary purpose behind these changes is to add that clarity to the regulation itself. So as you'll see in the statement of basis and purpose, and ALJ has already done this, and we've cited to that case. But these new changes will make it clear in the regulation itself what the requirements are. Importantly, we're also including an exception to allow for late-breaking issues that have been identified during the trial process to still be heard during the hearing process in front of an Office of Administrative Courts if they weren't reasonably ascertainable during the public comment period. This does put some goalposts around when issues should be identified and clarifies the requirements to identify issues during public comments. Do you want to say something? Sorry, I thought you were pointing to me.
No, I just want the additional language is to clarify issues that were raised during the final permit, not the
Okay.
trial process.
Okay, thank you. Sorry about that. Next slide. So I told you I keep this a little light. So the second purpose is to require that commenters identify the issues at a time when the division can actually do something about them before the litigation starts. The purpose of having that public comment period is to allow the division to collect information that informs its final decision. So in other words, if the division doesn't know about an issue because it wasn't identified in comments, there's no way that it knows there might be another more appropriate approach for the permitting process. If issues are only raised during litigation, it makes it much more difficult for the division to efficiently make changes, and it ends up wasting our resources. Next slide. Finally, as I've probably already mentioned a few times, another driver here is to ensure that the division resources are preserved in cases when an appeal occurs. We only have 3.5 attorneys representing us on all of the matters before both the commission or before the courts. One single contentious permit appeal can have a dramatic impact on our division's resources and our ability to take on new matters and challenges, particularly if we're involved in contentious discovery battles about the scope of what's being reviewed before the Office of Administrative Courts. Litigations can take up a lot of division resources as well. In past, every permit writer who wrote a permit that had got litigated had to be deposed and called to testify, meaning that those permit writers would have to spend days, if not weeks, both preparing for the depositions, having their depositions taken, preparing for their testimony before the Office of Administrative Courts, and then spending days in the court itself testifying in the hearing in front of administrative law judges. The more wide-ranging the scope of litigation is, the longer those processes take. This is time that we could use writing permits and getting those issues. So it's a very real concern for the section as a whole. Next slide, please. So where does the remaining quarrel remain with the joint stakeholders? Right now, it is just limited to statement of basis and purpose language. The joint stakeholders had proposed some additional language be included in the SBP language that we thought was unnecessarily expansive. The division would like to keep the SBP language very tight so there's no room for misinterpretation. Next slide. For an example, if a broad interpretation of raising issues is added to the statement of basis and purpose language, it could have unintended consequences that result in the exact kind of confusion that we're trying to avoid with these changes. So as an example, whole effluent toxicity or wet testing is an issue that if it was allowed to be raised broadly, may not allow the division the exact kind of notice it needs to make appropriate changes or respond to those comments in public in response to comments. For those of you who might not know, wet testing is a specific water quality test performed by a laboratory in which lethal or sublethal effects of discharged effluent is tested on certain aquatic species. In other words, a sample of the discharged water is poured into a test tank at specific concentrations, and the lab tests how many of these test animals live, die, or are harmed by the presence of the effluent. Wet testing is pretty complicated, and over the years, both the public and permittees have raised many questions about how these tests could be performed, such as what concentration of effluent should be used in the test, what constitutes a sublethal effect, should acute or sublethal tests be required, what species are used in the sublethal test, and where should the test be performed? What part of the and more importantly, what part of the testing does the division have regulatory control over, and what parts are controlled exclusively by the EPA? So in this situation, if one were to simply raise the issue of wet testing, it's unlikely to provide the division with the type of notice and the opportunity to resolve a claim about wet testing prior to litigation. Say if a claim was that the division used the wrong test species for sublethal tests, or a claim that the division is not required to follow the EPA test procedures. More information would be needed because these are in and of themselves complex issues that, before hundreds of hours of technical expert or attorney time is used resolving them through litigation, the division should have an opportunity to address and possibly resolve during the response to comment process. Next slide. For that reason, we're here today to ask you to keep the statement of basis and purport language that's proposed in Exhibit 5 without making any additional changes. We do not believe that additional language is appropriate or necessary in this section. Next slide, please. So in conclusion, we have a summary of our requests here in the next slide. We're asking here today that you adopt our proponent's Exhibit 4 as modified by the consolidated proposal. That's what's before you in Exhibit 5. Importantly, including the language in 61.52D(ia), that's the language for undue delay or unduly delay, and adopting language that has been proposed in the Statement of Basis and Purpose for Regulation 61.7 without any additional modifications. With that, we're available for any questions you may have.
Ike?
So was
Yeah. I was also forgetting.
Okay, good. Okay, we were all deferring to Rick, and he was looking at you. Yeah, okay. I'm curious about you mentioned transparency with respect to the undue delay part of this, and there were several reasons listed for why a delay may occur. But how do you envision that gets communicated if it's a delay on the side of the division?
So let me follow that up. Are you asking what our process might be to communicate that to the requester, or not exactly?
I guess so. I think so. What popped into my head was I'm trying to remember one of the exact examples you used, but it got. I think it was about resources, right? That the person power within the division could not respond to something in a timely manner. Not that we need to debate what timely manner means, but that could be one reason. So is that just a notification that you would imagine goes to whoever is requesting the permit, or is it broader than that? I guess I'm just trying to envision that process.
You want to answer that?
Well, I don't know that I don't remember having said that. I'm sure that I mentioned division workload.
Yeah.
And that is, I mean, it's a factor. There are, and these guys can speak to it more specifically about what the requirements are to get permits out the door essentially. But that's not, that's why the flexibility is so important, because that's not the be all and end all. It behooves the division and everybody to, be able to get as much information and be able to get a better product out the door. But maybe in certain situations, a balance is needed, rather than extending a comment period for 90 days, limit it to 45, because, we really need to keep this moving along. And we don't see why 90 days would really make that big of a difference unless, there was information given to the division that says it's going to take us 90 days, it's going to take the commenter 90 days to gather, this additional information, that kind of thing. But you can.
I was just going to add on briefly that the way we've done this over the past year that I've been here is, sorry, it's like bad old habits die hard. Just like have a line here, like do not cross. We have begun to communicate this both to the requester and on the permit public notice page generally. So we've issued a letter to the requester explaining what length of time we're extending that comment period to, and then putting that on our webpage as well, so it's clear to all members of the public what the expectation is, and that it's applied equally across anyone who would be commenting.
Okay.
So I hopefully that helps.
Yeah, it does. Thank you.
Can I just add to that? I guess in that situation, would you, if another party had already submitted comments, would they be specifically told about the extension? Just because they're probably not checking the website the way someone who hadn't commented might be.
In past practice, that is the way that it has worked. So using the Sierra Club as an example, I believe, if I have my facts correct, Excel had already submitted their comments after Sierra Club had filed their request, or before Sierra Club filed their request. So we worked closely with Excel, the permittee, to make sure that they knew that this was happening. I think the other advantage we have here is if you choose to adopt the responsive comment period too, it's not the last chance that parties would have to kind of refine what they've already presented to the division in a situation where there's multiple commenters and maybe an issue that needs to be responded to.
So please, you've already brought one president into the conversation about is. Maybe we should bring a second one. In paragraph D, small I, A, wouldn't you want to make in the second sentence who is the decider? And that you could do that consistent, please, with the comments you've got on that exhibit, page 6. You would say the division in its sole discretion decides.
I think that's a good addition. I'm going to refer to my counsel here to weigh in as well, but that's a good point. It is a little bit vague the way it's written right now.
And it also would create, I think, an opportunity for an appeal on that point alone.
Well, and that's looking that suggestion over. One thing that we did feel was important in statement of basis, and I think you'll see there in our rebuttal statement, is making it clear that to the extent someone has a quarrel with our decision to extend a comment period or grant a responsive comment period, we're asking that people raise that right away. So we really know that that's going to be an issue, and we have the opportunity, again, to potentially correct that error.
Right. So, yeah, I don't disagree that some clarification, I guess, yeah, it's one of those situations where you look at something a million times and you think, well, sure, it's clear as anything, but yeah, but it wouldn't hurt to add some clarification there.
Yeah. Now I'm pulling it to me. Did you guys consider or discuss with stakeholders a list of reasons why you would not grant an extension, as opposed to just using the term of art undue delay, which would be a lot of discretion for the decider? A little more notice to people about what the reasons that you might not be able to grant an extension, as opposed to this broad sort of legal term that typically right, it's set up for judges, right, to make a decision about what undue delay is or not. Here, we're talking about, a permitting agency. And you gave one example. I imagine there are a few more, and could they be listed? Did you discuss that?
We did discuss examples, and they could be listed. Again, in reality, the division, I can't think of a situation where the division has ever just flat out denied an extension of a public comment period. If anything, it might be used to limit it, from 90 days to 45 days or, whatever, based on whatever circumstances are at play in that particular process. And we felt like the statement of basis purpose language just kind of created, some considerations for the division, but we didn't think that going into detail about situations would necessarily be more informative. But if you all do, we certainly can.
Yeah, maybe just to dovetail with that a little bit, was mentioned on the slide, but we did talk about different language options, and I think that's where we really struggled to get on the same page. I think our main takeaway was we do want to keep this somewhat broad so that the division has that ability, again, when it communicates to the requester, to explain the reasons why it may not be granting the extension, the full extension request, and to really do that on a case-by-case basis, depending on whatever else is going on. The 316B cooling water intake structure rule that we mentioned was a pretty unique example. Others may arise, and at that time they may be unique in and of themselves. So that's kind of where we were coming from, but that is a good piece of feedback.
I want to acknowledge the good work that's been done here between the joint stakeholders and the division. I can understand that is one of the more sensitive areas that the division deals with the public. It's not theoretical. It's not somebody else's stream. It's very specific to a discharge or to a water system. So I think there's an inherent tension between the permittee and the permitting agency. And I think that you've done a remarkable job of presenting us with changes that do improve the public's ability to participate in the process and to try to resolve things through the hearing process instead of having to go to court to adjudicate it. So I want to thank everybody for their efforts here.
Thank you.
I just had one more question. Can you just go over the wet testing a little bit again? I'm not sure. No, I'm just not sure I understand the example. Like, is it, so for example, let's say a permittee has an issue with the species used. You're saying if they don't bring that specific issue up in their public comment, they can't bring it up later, I think is the justification, or essentially what your language tries to make clear. But how likely is it, and maybe that's the wrong way to say it, like, is your fear that someone's going to comment with something totally unreasonable, like we shouldn't have wet testing at all, and then go through some litigation process where they then find some more detail to actually fight, but they're going to make a statement? I guess I just don't understand exactly what you're trying to avoid.
So we don't want to sort of get into all the details of past litigation. I don't think that's super productive for anyone, but we are basing these examples on actual litigation that the division has been involved in. So in terms of these aren't theoretical concerns. So what we were trying to get at with the wet testing is if somebody raised in their comments, I disagree with, the wet testing requirement, or the wet testing requirement is wrong, or that broad identification of wet testing as an issue wouldn't allow the division to get to wouldn't allow the division to respond to an issue like you pick the wrong species. You pick the wrong species is a really important issue in wet testing. And if somebody, Ellen can speak to this, if someone says you picked the wrong species, in our response to public comments, that would be a page and a half. That would be, no, this is why we picked the right species, or maybe we did pick the wrong species. Let's go back and look. Let's look at EPA's, 40 CFR 136 and see what it says. That's a really complicated issue. And so just saying, the wet testing is inappropriate wouldn't allow the division the opportunity to resolve that specific issue of the wet testing species. Most issues aren't going to be that in the weeds, but that's why we want to make sure that the language in the statement of basis and purpose is really clear.
If I can, briefly add to that, again, without trying to rehash old wounds too much. One thing we had encountered in the past specific to wet testing was there was really I would describe a legal question as to whether or not the division had the authority to make a change in the testing species, or if that fell exclusively with EPA. Unfortunately, because that wasn't identified early, there was heavy, extensive technical briefing on the sort of underlying arguments about the validity of using one species under another. And it had really real impacts. The permit writer who was involved in that case pretty much dedicated an entire calendar year to that specific litigation. So that meant no other permits being issued by that permit writer. So these can have pretty dire impacts on our ability to actually get our jobs done. So that's part of the reason why we've really been steadfast in trying to advocate for the position that we have here today.
Anyone else have comments, questions? Okay, well, thank you. And I guess the joint stakeholders will be up next.
Thank you.
Good afternoon, everyone. My name is Justine Beckstrom from Varnish and Reich, and today I am here on behalf of Centennial Water and Sanitation District, the City of Fort Collins, Town of Fraser, Plum Creek Water Reclamation Authority, City of Pueblo, Tri-State Generation Transmission Association, and Public Service Company of Colorado.
Can you swear yourself in?
And I swear to tell the truth.
I'm Christine Joachim with Brownstein Hyatt Farber Schreck. I'm here on behalf of Metro Wastewater Reclamation District, I can speak, excuse me, Parker Water and Sanitation, and Dominion Water and Sanitation.
I'm Matt Montgomery of Hill and Robbins, and I'm here on behalf of South Platte Water Renewal Partners, and I swear to tell the truth.
And I do too. Thank you.
Okay. Tricia just passed around some slideshow slides for you. We decided to print out the whole presentation since we had sent this in a little bit later in the day on Friday based on working on a consolidated proposal. Go to slide 2, please. There's not more. No, it is more. Okay. So together, we're here today to represent a group of 11 entities that filed a joint responsive pre-hearing statement in this rulemaking. We've included a full list of those entities on this slide. Next slide, please. In our response to a pre-hearing statement, we addressed 7 issues, and I'm happy to tell you today we hopefully will not take you the entire 30 minutes we've been allocated, as we have fully resolved 5 of those 7 issues. Can you click, please? Okay. Next slide, please. Okay. So as you heard from the division, we worked with the division to resolve the outstanding issues and have been able to reach resolution on almost every single issue that we came into this hearing with. We'd really like to thank the division for the time they spent with us, especially this past week, hashing out some of these remaining issues. And so we agree with the division's Exhibit 4 as modified by Exhibit 5 with 2 exceptions. Okay. And these are the 2 remaining issues, and you just heard about these from the division. So first, our issue 1 would be the use of the phrase unduly delay regarding extension of the comment period, and that is in section 61.5 2DIA. And then the second is really just aspects of that issue 4 on the previous slide, clarifying the requirements related to the scope of an adjudicatory hearing and primarily the statement of basis and purpose language. Okay. So, as you heard from the division is proposing to add language in Regulation 61 to explicitly allow extension of the public comment period on a draft permit. And this language includes a term that we've disagreed with, specifically unduly delaying permit issuance. We specifically disagree with the terminology chosen by the division. In our opinion, it is vague terminology and it has a potential misinterpretation, including even in light of the statement of basis and purpose language that's been included. So on this next slide, set out kind of the areas where we think we're in agreement on this issue and the areas of disagreement. And I believe that we're in agreement with the division that there's a narrow set of circumstances where extension of a comment period would cause harm, such as in those cooling tower permits, some of them need to get out before July 2018. And we are also in agreement on the statement of basis and purpose language that the division has proposed. There are really only 2 kind of areas of disagreement on this issue. It's the use of the term unduly delay, and specifically whether unduly is a broad standard, as we're arguing, or a narrow standard, as the division argued in its rebuttal. Next slide. So kind of looking at the differences between unduly and harm. So when I went into looking at what unduly really means, and Merriam-Webster's uses it to define as excessively. Black's Law Dictionary defines unduly as see in reasonable context. And in the legal concepts, reasonableness can be a very broad standard. Now, in a following rebuttal, we worked with the division and suggested maybe we would place that with the word harm. And harm has a more consistent definition. Merriam-Webster's and Black's Law Dictionary both use injury, loss, damage. Those are pretty clear concepts in the law and in a non-legal context. And so we believe that it's a more narrow concept in that it matches the standard. Most importantly, it matches the standard the division's included in the statement of basis and purpose. So on this slide is some language that we suggested to the division following the rebuttal. And so we would propose to remove this unduly term and instead change this last sentence to say, additional time shall be granted to the extent that a commenter who requests additional time demonstrates the need for such time, and the extension does not result in a harmful delay in permit issuance. If you go to the next slide. So here's the statement of basis and purpose that the division had mentioned during its presentation. And I'll note this first part of the statement of basis and purpose comes from case law interpreting EPA's provision, which doesn't have any mention of this delay concept. It just stays as so long as the commenter demonstrates the need for such time. So in bold, we've included kind of this language that we believe the harm relates to, and it's such as the division's obligation to timely issue or deny a permit application and the potential harm from delay in permit issuance or denial. So we believe that the factors the division needs to consider are already in there. We pulled those from EPA case law. And so we would recommend that the language be changed. If you go back to the previous slide, we would recommend that it be changed to this language where we would specifically refer to a harmful delay rather than use a legalese term of unduly delay. Go. Two slides, yeah.
Okay. Now we're switching gears to 61.7C. And as you heard from the division, the proposed revisions to Regulation 61.7C are meant to address a concern that issues with permits are being raised during the adjudicatory hearings that were not previously raised during the public comment process. So specifically, the proposed revisions make explicit that only those issues of law or fact identified during the permitting process may be subsequently adjudicated, unless the issue was not reasonably ascertainable from the draft permit. While this is normally an issue that would be addressed by a hearing officer and resolved during that phase of the process, the division is proposing language that would require that parties appealing permitting actions demonstrate that the issue was raised during the public permit process, and if it was not, explain in writing why such issues were not reasonably ascertainable during that public comment period. While many of the joint stakeholders feel that the proposed changes to 61.7C are unwarranted and may lead to actually additional litigation about how much evidence needs to be presented in order to preserve an issue for an adjudicatory hearing, or whether an issue was actually reasonably ascertainable, we understand that similar language appears in the federal regulations, and that this may just be an additional hurdle that permittees and others are going to have to overcome if they decide to appeal a permitting decision. Next slide. However, the joint stakeholders are proposing additional language to be added to the statement and basis and purpose to clarify the central reason for this regulatory change. The proposed language that we've provided is a purpose of these revisions is to ensure that issues interpreted broadly are brought to the division's attention early in the permitting process, so the division has the opportunity to address the issues prior to reaching the adjudicatory hearing procedure stage. This proposed language explains why it's important for issues to be identified early on, specifically so the division can address them prior to a costly and time-consuming adjudicatory hearing. During the stakeholder process and in advance of this hearing, we presented this language for the division's consideration, and as you heard in their presentation, we were told that it was not necessary to state the purpose here, especially, and what they noted to us in the previously was that it's not the only purpose of the regulation change. While we recognize that this is not the only purpose of the regulatory change, it is essential to the change and emphasizes for permittees and other stakeholders why it is so important to be actively participating in the draft permit comment process. Next slide. So in summary, the joint stakeholders respectfully request that the Commission adopt the Division's Exhibit 4 as modified by Exhibit 5 with these two revisions. First, revise Section 61.5 as set forth on this slide and discussed previously, and to add language to the statement of basis and purpose in 61.7C to clarify why it is important that permit issues are raised early on in the public comment process. And I'll just end by saying thank you very much for the time and consideration that you guys have taken to this, and especially to the division, because we worked out an enormous number of issues over the last week and a half. So I think we've really come a long way. So with that, we'll take questions.
Rick?
Thank you. Thanks for your presentation. That was very succinct and nicely done. And I want to make sure that you understand that the praise I spoke of earlier for the division goes to the joint parties too. I think it's great that so many entities chose to work together on this and try to find solutions. So thank you for your good work. You presented one paragraph that you're suggesting be added to the statement of basis and purpose. In Exhibit 5, there's two sections that says that the joint stakeholders have additional language here, which the division rejected. You're suggesting just this one statement be added?
Yeah, and I can raise that. And you can certainly consider it. We originally proposed additional language that said generally supporting information is not required in order to identify an issue of law or fact, and that was going to go in that first section. That language actually comes directly from the preamble to the federal regulations to really explain how much you need to provide in order to identify an issue for an adjudicatory hearing. Right now, we're not putting that forward. It was an area that we knew we weren't getting much traction with the division on. But I think that the other language that we propose is definitely more important to us. But I think that's something that we think you should consider if you want to add some additional clarity to it. I do think that those issues of law and fact and whether or not they've been raised previously is still going to be something that's going to be addressed by a hearing officer, regardless of what we put in here.
Thank you. Oh, you want?
Oh, sorry. Can we go back to the slide with the language?
2 slides.
Yeah. Nope. That was it. Yeah. Is it, I guess, and I'm not sure you can answer this. Does it just need more refinement? So maybe instead of a purpose, maybe one of the purposes for these revisions to address the division's concern that there's more than just this reason for making the changes. And then I think I also heard from Ellen that, you know, the wet example, just raising there's a wet issue rather than there's a wet issue, you know, could it be interpreted broadly but with enough specificity?
Mm-hmm.
Are there some wordsmithing that could be done that would make it work for both parties?
Yeah, this is actually a couple iterations of language that we've tried to propose. It was originally the purpose of these revisions is to ensure, and we changed it to a purpose of it to sort of highlight the fact that it might not be the only reason. And I think we're willing to discuss other options for languages to clarify it that would be agreeable to the division. That we just haven't been able to figure that out yet.
And I do think that some of our concerns when we first put forth this language related to the use of raised versus identified. So some of those have been resolved with, we really appreciate the division's agreement to use the word identified, and that I think helps some of the issues, concerns that we had, but I would say it's primarily the later part of the sentence, the bringing it to division's attention early on, and I believe that they mentioned in their presentation that is one of their concerns. And we agree. I mean, we don't want to waste our resources either. We want the issues out early.
Yeah.
So please, the same questions about is and the decider. Is the division the decider with regard to DIA? Are they the decider of whether to grant an extension?
So I believe we did toy with language that specifically indicated the division in this section, and ultimately our proposal was based on EPA language. So the language that was proposed by the division in 65.1 or 65.12 DIA is almost entirely from the EPA language, and EPA doesn't specifically state the EPA makes its decision. So the language was just that I think it suggests the division makes this decision, and the statement of base and purpose clarifies the factors the division chooses. But I think we prefer to leave it a little more open-ended so that it wasn't just the division, their sole discretion gets to decide we can't extend this, because there are situations where we need an additional amount of time to respond. I mean, permits could be backlogged for many years, and there are a lot of different changes that are being addressed in permit comments. And it would be more effective to include them in an extended comment period versus in a 30-day comment period and then bring them forth in adjudicatory. Yeah.
You're conflating two things. Who's the decider and how should they decide? Do you agree they are the decider?
And I missed it when you asked it.
Sure. Is it the
decider.
division that is the decider of whether to grant more time?
I think they are.
Yes.
So you would be okay with saying the division in their discretion makes that decision?
Yeah, I'll have to confer with the team, but
So
that doesn't sound problematic to me, because I don't think it's different than how it's going to play out.
If that was one issue, they were the decider, then what you're trying to balance, it seems, is the benefit or the potential benefit of more information with a duty or an obligation to make timely decisions. Are those the two fulcrums, the 2 points? So why not just say it that way? You know, the division gets to make this decision in their sole discretion, balancing the potential benefit of more information with the division's obligation to make timely permit decisions.
One point I'd like to make is you've used discretion and sole discretion, at least in a contract term, tends
Goofy.
well, it tends to mean that you can act arbitrarily, and I could just say, I don't want to do it. And so I would
take out
just, thank you.
So, I think that clarified one question I had, and now I realize I'm in a room with way too many lawyers, but I'm gonna ask this question anyway. When we go to the other, can we go to the harm statement real quick? The proposed. Oh, okay. The with the red text in there to yeah, there we go. The harmful delay. So I'm concerned that the use of the word harm would infer responsibility to the division that it doesn't have. In other words, that they were causing harm, where I don't think that's the intention here, because I think my sense is that the intention is to keep from having a situation that might be problematic because there's no permit, and therefore harm may result from that situation. But I worry that the way this could be interpreted by someone, and someone who's not a lawyer might be interpreting this the wrong way, to suggest that the harm is being that the harm is the responsibility of the division and not some other situation. Maybe it's better to ask a question. Is the intent here to put the responsibility for a harmful situation on the division?
I would say that it's not necessarily in every case. I think we intentionally left this a little open-ended on who the harm was, who was going to be harmed, because there are certain instances where an extension of comment period would harm the permittee, and there are certain instances where it might harm the division, and there are some instances where it would harm both. And so I think we wanted to keep it a little bit open-ended and weren't necessarily inferring that it would be the responsibility of the division.
Okay, maybe. Okay, fair enough. Well, I guess then, going to the other language bit, I worry a little bit about starting out that paragraph with what was it, a purpose, right? Because someone like me really wants to know. Okay, so I'll admit to being an engineer. I would want to know what all the purposes are, right? If you're going to tell me one purpose, then what are some of the others? And I worry that suggests that you're about to provide a laundry list, and if that laundry list isn't there, does that cause an even bigger problem for trying to figure out what the other purposes might be? And then I almost want to say, we should probably be careful about the unknown unknowns. I'll allow for the eye roll. And does that generate greater uncertainty in trying to find other purposes if you start it that way? But maybe David, the conversation with David sort of closed that a little better. I don't know.
Well, I understand that concern, definitely. And I think maybe one way to address it would say, these revisions will ensure that issues are brought to the division's attention early, and not even call it a purpose, just say what it's doing. And then you resolve that hanging purpose thread. And I get what you're saying.
Okay. Thanks.
Going back to the harmful delay versus unduly delay, do you feel like, I'm not sure. I mean, I can see all sorts of, I can see where this extended comment period could be used for mischief by any number of people. And some of that mischief and delay could cause harm. The cooling tower example is a great one, where if it delayed past a certain point in time, significant more facilities. Do you think harmful is, I wonder if you could accurately interpret impacting the division's ability to issue permits in a timely manner. Is that covered by harmful? I mean, I don't know if that's a harm. That's making their life difficult, but I don't know that you've harmed the division. So.
And I think our interpretation of that would be that the division would consider a harm or an injury to them if they get really behind on their workload and they need to issue this permit in a timely manner. And I do think we've been we were open to some different word choices if that would be more appropriate. We're really just concerned about the use of the word unduly delay. It's a legalese term that it doesn't really appear in a whole lot of legal provisions anymore. And you're hearing from several different attorneys today giving it different meanings, and that gives us some pause.
And I'll just add to that, and I think it's a point that Justine raised during her presentation. And in the statement of basis and purpose, when this section is explained, the word harm is being used, not unduly delay. So it's also a consistency piece. So it's just an additional element to it.
Yeah, I guess one thing I would point out, I mean, when I think about this, I mean, what we're trying to get with, I think, with harm is that it's something sort of objective or tangible that the division has to point to essentially say, this is why we can't give you the extension that you've asked for. And with unduly, my concern is that it's somewhat subjective. And so there's no, what are you pointing to? This is why we can't. It's just, we said it, therefore it is. And that's really, I think, fundamentally what undergirds our concern.
I should just leave this to the lawyers to figure out, but it seems to me that harm is one of the potential reasons for not issuing a delay or not allowing the hearing to be delayed. But it seems that there's other causes that the division may want to move this along, such as workload and some of the others. So I'm trying to understand, is harm really the only reason to not allow an extension of time on hearing the permit?
Do you mind going back to a few slides with the statement of basis and purpose is a few more? Yeah, there we go. So kind of take you back to the statement of basis and purpose. And so the EPA's version of this regulation just says that the extension of time shall be granted so much as the commenter demonstrates the need for such time, and it ends there. And this unbolded text in this slide comes from case law interpreting the EPA provision. There are multiple factors that can be considered, such as balancing this public's desire for an extended review period, whether the public has received a meaningful opportunity. I think those factors are captured in the language that's already in there before you get to the harmful delay. The harmful delay aspect or the unduly delay aspect was proposed by the division. And in our responsive, we opposed that clause. We would have preferred the EPA language and then just using these factors. But kind of as a compromise, we're trying to figure out a word that we can include that doesn't have the same potential misinterpretation concerns as unduly delay would.
I keep thinking back to the literally hundreds of IGAs I've signed or negotiated in my career that referred to approvals, and with the clause that subject to approvals, which approvals shall not be unreasonably denied. Is that the word we're looking for here? So unreasonable delay.
I think we would want to stay away from the use of reasonableness, unreasonableness. It has its own kind of meaning.
Several of those were drafted by some firm.
Yeah. In this context, I think there's a fear that the unreasonableness might be a little bit too subjective in some instances. I mean, what the division might find reasonable or unreasonable might be different to what we find reasonable, unreasonable. So I think I would hesitate on using that specific term instead of unduly.
I will say you guys you're highlighting all of the issues that we have been struggling with for literally months. And that was part of the reason in our original responsive pre-hearing statement, we were just advocating to cut that phrase off, because you can have the explanation in the statement of basis and purpose that gives the division that authority to end the range of different reasons why they might not want to delay permit issuance. But yeah, you're highlighting all of these issues that we are having as well. So
So I appreciate that the division gave an example and you guys referenced the same example as a reason for some type of language here. Can you give me an example of what you're concerned about? I guess I'm not sure that the division can't say that anything you're concerned about is harmful or unduly, like, I guess I don't understand exactly what you think the difference is going to be.
I can give you an example in kind of more of a general terms. So this concern can arise, as you probably have known if you've attended any water quality forum meetings lately, division has a pretty extreme backlog in permits, and they're working hard in trying to get rid of that backlog, but many permits have been administratively extended for years. And at times compliance schedules will expire, even if they've been extended past the expiration date of the permit might expire before the division gets a permit out. But the permittee kind of has to weigh this risk of, well, do I want them to get the correct permit, or do I want to have a permit appeal to try to figure out those issues later on? And so the division might say, well, there's going to be a harm because this compliance schedule expires. And the permittee might say, well, but if we work together and we have 30 more days in this 30 more days of comment period, maybe we can hash out all the issues, address everything early, and then avoid later on having to go to an appeal process. I know that's not super specific, but I think it does come up in situations where a permittee might have different interpretations of the delay than the division would. I don't know if you have a more specific example.
No.
I mean, I guess what I'm saying is that example, they were harmed, right? So the language in this doesn't necessarily matter, right? I guess I'm looking for what situation would happen that are you concerned that they'll just say no because they feel like it? Because overall, harm is pretty vague, and according to what we're discussing now, could be as simple as they want to get the permit issued.
And I think our concern is that unduly would provide them more of that than the harm standard. But as you can see, we all kind of are putting different interpretations on this word, which makes it a little bit complicated and maybe suggest that we should just keep it in statement of basis and purpose in terms of interpretation and take out unduly, take out harm, because we don't want to provide different interpretations in the future versus what we're all trying to decide right now, what we mean by the permit extension period.
So I always assume good faith on the part of everybody in those kind of discussions, permitting discussions. So let's do that. Let's assume good faith on everybody's part. Nobody's trying to cause anybody harm. And assuming that more information can be helpful, but there's a point beyond which more information is not helpful. And that the agency has a duty. Just to think on a sentence that would say the division in its discretion, not sole discretion, may grant additional time considering the potential benefit to inform decision-making, which is really what we're all about, of additional comment with the division's duty to timely determine permit issues. And just to think on that as the discussion goes forward.
Are you saying that for the statement of basis and purpose for the regulatory text?
Well, actually, the regulatory test.
Okay.
Sure.
Kevin?
I'd like to ask if Jerry has some advice for. I have several questions, forgive me, but keying off of David Baumgarten's last comment and your comment, Justine, we agree that the division has discretion, and I think we can agree that the word reasonable or unreasonable is common in the law. Is that unreasonable or reasonable consistent with the division's discretion? Or let me put it in the reverse, would that be inconsistent with the division's discretion?
In other words, their discretion is subject to reasonable standard anyway.
I think the way I'm looking at this is trying to think about the circumstances in which the division's issuing extensions to public comment periods right now, and there really is no standard being applied. And so that's why we were looking back at federal language to figure out how that's been interpreted and what language we should be using. I'm getting to your question, I promise. And the reason why in our original proposal we were suggesting to leave off that phrase and put that language into the statement of basis and purpose, sort of explaining the circumstances that would make sense for the division to be able to issue an extension or any kind of extension of the comment period, is because we don't know how those words are going to play out, and there is that question of what is the legal interpretation of the terms. Unduly and reasonableness are really heavily weighted legal terms in our minds, whereas harmful is something that the general public and permittees who may not have a lawyer or members of the public who don't have a lawyer are going to say, well, they might not issue that because how is this unreasonably delaying the permit comment period? Whereas if they say harm, like I'm being harmed because they're not extending this public comment period and I want to make a comment on it. I don't know if that makes sense, but I'm trying to keep it simple.
That's generating a few more questions. As a practical matter, moving the language from the regulation into the statement of basis and purpose doesn't really have an effect, does it? I mean, if the language is in the statement of basis and purpose, everybody's going to look at that as guidance.
Yeah, it's guidance.
Yeah.
Absolutely.
Now,
it's not the regulation.
Mentioning harm, I'm a little confused. Are we talking about harm to the permittee as well?
In that it will not result in harm?
Yes.
Yeah, it can be anybody.
So is your proposed standard, although you think it's a broader term, putting that aside, is it a higher bar, something that's harder to prove?
Is harm a harder bar?
I would think a higher bar?
Higher bar. I would think it would be a lower bar, but if you guys disagree, feel free to chime in.
I think the concept, reasonableness, to go back to your original question, is a common standard in administrative law. And I think our goal here is to apply a standard that's more narrow than reasonableness, to more narrowly prescribe the scope of why an extension would be denied. And then I think the difference is that harm we view as more of an objective standard, whereas unduly we view more as a subjective standard. And so more that the burden of proof would be about pointing to tangible causes of harm when issuing the order, as opposed to just reasonableness is giving a reason. And so therefore any reason is essentially good enough to meet a reasonableness standard.
Well, to that point, would the practical or the potential effect of your proposal result in less public involvement versus more public involvement?
No, I think our proposal would result in more public involvement because it would make it more difficult, or would limit the number of opportunities to deny a request for an extension of time. And so in that case, that would, by granting the extension of time, conceivably equate to more public involvement.
So I guess I'm looking at it from the flip side of that coin, which is that the standard of harm is harder to prove, therefore there's going to be less extension of time on comment period.
I don't think it's harder to prove. I think it's an objective standard, and so to meet that standard, the division would have to identify the harm that's being caused, and that's why it's denying the request for the extension, as opposed to just giving a reason for the extension, which I think the harm then requires them to point to something objective. This will cause a delay, whereas a reason would just be it's going to take too long.
which could be interpreted as harm. I mean, isn't harm as vague, if not more so, without a definition?
I think the definitions for harm are more consistent, and it's not just a term used in a legal context. Unduly it doesn't appear in any of the Water Quality Control Act regulations or statutory provisions. It shows up in the CRCP and some random water rights provisions. I think it creates this different bar than, or a different kind of standard than harm does. Harm is much more understandable, and I think in 10 years, someone's going to interpret harm the same way as they would now versus interpreting unduly in a different way.
But the division's application of the phrase unduly is going to be subject to a reasonableness standard in any event.
Well, I mean, you can kind of take a look in 10 years and we see the unduly in the regulation language, and then we see the statement of base and purpose language referring to harm. And my question would be, so what does that mean? What does unduly mean? What does harm mean? What were they trying to do in 2018 to clarify this process? And I think we get closer in keeping a clear record and keeping everyone on the same page in 2028 if we're consistent in our terminology and if we're consistent with the standards the EPA applies when reviewing these extension of permit comments.
Yeah, but as time goes on, what constitutes undue or what constitutes harm may change, and legitimately so under the circumstances. That's a possibility, isn't it?
I think it's definitely a possibility, but I think keeping, as Justine said, keeping it consistent between the statement of basis and purpose language and the text in the regulations makes more sense, because if you have a different word that you're using in the regulatory text, if I was going to be interpreting whether or not that was, the decision was reasonable as a judge or some sort of deciding body, I'd say there's a reason they use a different word. I got to figure out why that is. And should I be looking at case law that explains what unduly means versus just having the standard be harm in both places?
With your indulgence, just one more question. Turning to the scope and getting notified or identifying issues for appeal, that issue is really a matter of, the issue here is timing. When does somebody have to bring an issue to the attention of the division? And, requiring early notification of an issue to be appealed is pretty fundamental concept in the law. You can't raise an issue in the Court of Appeals that you didn't raise in the district court. So it's really a matter of timing, isn't it? When does the division need to be notified? And it's really a matter of fairness, isn't it?
I think we're in agreement with you on that.
Okay.
I don't think there's any disagreement about the purpose of the language that's going into 61.7. It's a matter of clarifying for the public why they need to be doing this and why it's important. And it's about fairness.
Versus when they have to do it?
Well, I think that that's embedded into the language already.
And the division's proposing you got to do it in the public comment period.
Yep.
If I understand your proposal, it could be any time up to the appeal.
No, we're not changing the timing of it at all.
Okay.
Yeah, I don't know where. If that's in there, let me know where it is, because it shouldn't be in there. We're not proposing a change to when things should be raised.
Okay. Thank you.
If I may, I think our concern is, one, just how much to identify an issue or raise an issue, how much is required. And one of the concerns we have is that we not have to, on behalf of regulated public entities, have to submit very extensive comments just for the sake of preserving all sorts of possible issues going forward. Just because that seems, we don't want to create overkill just to preserve an issue for the purpose of appeal. And then on the flip side, if we do end up in an appeal, our concern is just essentially technical bars being raised to rather substantive consideration of the issue on appeal.
So you're concerned about overkill. Perhaps the division, I don't know, is concerned about underkill. I mean, in other words, you don't provide enough information.
I think that's exactly right. And so we're just trying to strike the appropriate balance between, to make it as clear as possible so that there aren't surprises. I think you've characterized the concerns on the division's part and our part accurately.
I have one more thing to this discussion.
So tell us what you're telling the truth first.
Yeah, Undue Water, South Platte Water Renewal Partners, and I swear to tell the truth. You know, on this raising issues issue, one other thing I think that's helpful to know is that there is a modification process in Reg 61 which allows a modification to correct technical mistakes, and that refers to errors in calculation, mistaken interpretations of law made in determining permit conditions. And so, you know, I guess in thinking about this, probably the worst case is that you go through, you can't raise these issues in an adjudicatory hearing, and then you know, you turn around and the discharger just files a permit mod request because something was missed. So I think there's, you know, and there's probably different sets of issues that, you know, that fall in that technical issues category. But that's just one other consideration in all this. I guess we don't want to avoid, we want to avoid, you know, excluding things that could be raised that could be easily addressed if there's time to do it prior to a hearing.
Dan, I'm sorry, I don't understand how the provisions for permit modifications apply to when you get notified or when you notify the division of your issues on appeal, and when to not grant an extension on the comment period. I don't see how modifications addresses those issues.
You know, the case I was thinking of is, I think sometimes a discharger will think that they've raised kind of the fundamental issue, and then, you know, the division may disagree. And then they may go back and do a deeper dive and say, okay, well, I really need to dig into the numbers on this. And they might find something else that's a technical issue, but they, you know, this may exclude them from raising that.
I think that's what the division is proposing, that they be notified of that at the time of public comment so they can go deeper into that.
And I think in most cases we try to do that. What I'm saying is that, you know, if it's going down a road that the discharger or the regulated entity it really is digging deeper, I think everyone tries to do that deep dive early on as much as possible. I'm just saying that there may be times that you realize the technical issue later in the process, and there is a process in the regulation that would allow that to be raised in a modification down the road. And it seems cleaner to address that up front if possible.
Anyone else? Thank you very much. And I guess next is, who's next? AFCARE.
Sorry, I should put this way over here. I'm Andrew Newhart on behalf of AFCARE. All right, test that. Sounds good. All right. So AFCARE in its pre-hearing statement, not pre-hearing, responsive pre-hearing statement, basically just supported the joint parties' proposal and the information that they provided. AFCARE had a lot of the same comments and same language issues, and just everybody wanted to provide the same red line, and that give you all about 3 or 4 different red lines to review. AFCARE talked about 6 different topics within its responsive pre-hearing statement, and several of those were resolved within the division's rebuttal, and we appreciate their work on that. Of the 2 remaining issues, AFCARE still throws its support behind the joint parties and the language that they are proposing. You know, the main issues with the unduly delay is that folks are worried about being able to make sure that the permit is right. They don't want a permit to go out and then have to come back and do a modification immediately upon issuance. And that costs money, that costs more resources, that costs more time. So we want to make sure that the permit's right the first time when it's issued. Now, there are times when things do need to go out. Maybe a discharger does need that permit, or the division has a deadline, you know, with the cooling tower example. So all those are legitimate causes. But we just want to make sure that, you know, if a request for additional time is made, especially if you're diving deep into the details for the adjudicatory process, that you have the time to do that, that we can get things right. As far as the adjudication, you know, some of the concerns were regarding how many comments do you have to submit? How much evidence do you put in? You know, for example, if you have a issue with a reasonable potential finding in a permit, well, you may think it's pretty obvious that there was a mistake made on this side, but there may have been a different mistake made, or several different sets of comments that you could provide on that in order to keep things kind of short and not have to make a huge data issue or a huge calculation issue or yet a third issue out of it. You're going to pick the one that you think is most reasonable and most likely going to, you know, result in the change that you think you're requesting. Sometimes you may not be able to provide all information, and I think if the division needs more in that instance, they should be able to contact the permittee and say, hey, what exactly did you mean by this, you know, before that permit is issued, therefore maybe avoiding an adjudication process. But other than that, again, just AFCURE wants to throw its support behind the joint parties statement and their proposal, and that's all I have for you.
Thank you, Andrew. So I have an empty sign-up sheet for public comment. Is that correct, or is anyone out there here to comment on Reg 61? Okay, I guess let's bring the division back up, and then we'll, I guess, probably take a quick break after that.
It's hard. I think we were going to respectfully request for a brief break, if that's all right, if we have enough time here. I don't think we need much time, but just a second to regroup. Yeah. Thank you.
So we'll do 2:45.
Great, thanks.
Thank you. These are all really? Serious? Yeah. Other people are playing? Oh, God. Oh, man. All of that in the fireplace. It's the writing books for kids. They just get stuck in my head. I can't get them out. I'm playing all day, all night. Can't sleep at night. I'm a pal fish with a wait, I'm a puff. I don't even remember now. It's out of your brain. Puff fish with a pout face. So I spread my dreary berries all over the place. Love. Yeah. Oh yeah. Oh yeah, we have all. Yeah. Oh yeah. It's not to be amazing. Yes, oh yeah, the other boy in charge is a good one. Yeah, something changed. Really complex things down. I only think
Eric. Eric said the water was
You mean right now?
Yeah.
Somewhere.
But no one can something from it.
Yes. Yeah. Well, your name's not working.
Not anybody else's fault.
I did, yeah. How are you? That's the number of projects.
Yeah.
Oh, wow.
What is this? And there's, you know, in the pages, there's nothing in there about that.
Other than that, it's not. It is right what they were saying. It's massive.
Well, you know what?
Oh, really? Yeah, I couldn't identify. Yeah. I know. Yeah, it is a little bit strange. I enjoy like kind of.
Well, and then the screen, they have those emails.
Oh, right. The stormwater.
Yeah.
You can see.
Okay.
I missed a lot of that.
Yeah, I just heard the very tail end of it.
Yeah.
It sounded like it was asphalt. Like there was something like in that.
Yeah.
Because you guys come today.
Yeah.
Characterize it not at all. Kind of intense. Yeah, I heard that part.
I did hear that.
But I couldn't figure out. It worked out right. They might do it later. They told me, I know they have.
I did hear it. Yeah. I did hear people do that. I was like,
All right, let's get back to the division's closing statements. Did you have enough time?
We did, and thank you for granting that additional time. We appreciate it. I'm going to stall for just a second because I think Annette's actually going to dive into our closing statement here. But thank you for that break.
And my husband needs to pick up the carpool. So that's all I'm saying. I'm done. All right, here we go. So I'm just going to talk briefly about the unduly delay, as if we haven't beaten this to death enough. But just to reiterate what the division said in its initial statements, we think that it actually does reflect what the division does now, which is looking at reasonableness, as Jerry pointed out. And to that end, if we use the term unreasonable delay, I think that would be okay as well. I think that it encompasses kind of that spectrum of circumstances that we're looking to try to address. I just wanted to say, in terms of the testimony of the joint stakeholders, they stress that the statement of basis and purpose language should be consistent with the regulatory language, and we agree. But they focus on the words harm from delay in the statement of basis and purpose, but they ignore the fact that right before that, it talks about the division's obligations to issue or deny a permit application. And that's a separate concept in the statement of basis and purpose from the concept of harm. They're listed separately. So so harmful, again, we think is just a little bit too narrow. Both terms are subjective. Unduly and harmful, they're both subjective. It's just that harm is narrower, I would think, arguably. And so again, just getting back to what we're trying to accomplish here, in my experience, my 20 years here, I've never seen the division out and out deny an extension of a public comment period. We may limit it from what has been requested for various reasons. Every situation is a little bit different, but it's never arbitrary. There's always a reason. But it comes down to reasonableness. And for that reason, the division would be okay if the commission would like to go to substitute that word for unduly delay, unreasonably delay, or Commissioner Baumgarten's suggestion even, I think, gets to what we're trying to accomplish as well.
And then briefly, I don't think we have a lot to add on the statement of basis and purpose language with regard to 61.7. I think you heard from us the concern there. I think this is part of the reason for this proceeding is to add clarification. We believe that the statement of basis language that's already been proposed does the best job of adding that clarification, and we don't want to muddy the waters anymore. And so we'll just leave it at that. And if you do have any additional questions for us after this closing, then please feel free. Thank you very much.
I'd like to understand your concern about inserting the paragraph that the consolidated group asked. I think there was discussion that perhaps it could be modified to say these revisions are to ensure that issues interpreted broadly are brought to the division's attention early in the permitting process, so the division has the opportunity to address the issues prior to reaching an adjudicatory hearing procedure stage. You still have concerns about including that? That seems like a reasonable statement.
Well, I think Commissioner Gosef hit the nail on the head here. I do think that we just want to be sure that, we're not just giving a single example here, that we're encompassing the idea of wanting to have the full discussion in the public comment period. That's really my biggest concern here. And our biggest concern here is ensuring that we have all the information necessary. We're not just raising narrow issues. I do think the modified language gets us closer if the commission chooses to go that direction. I think from our position still, we think the greatest clarity is maybe staying silent and keeping it where we are. But respectfully, I think that's a decent compromise. Thank you.
Well, I just have to ask you the same question. The difference between harmful and unduly is, I don't see any real world example other than if you both claim, I think, that harmful is a more narrow interpretation, which means that there's more opportunity potentially for public comment, because I guess it gives you the division a little bit less opportunity to reject an extension, but I don't actually see any real difference, because technically, at least as described by the joint stakeholders, one of the harms is essentially an unreasonable delay.
So I think Commissioner Biggs might have pointed this out, that I think it could be argued that the division's responsibilities or obligations to get permits out the door in a timely fashion may not be considered harmful. if they don't meet that obligation. It may be considered, unfortunate, or what's another word? But I think it's inconvenient, exactly, but harmful. I think it puts the division at a disadvantage. And I also pointed out that in the statement of basis and purpose, the way it's worded right now, it talks about the concept of harm in a different way. It talks about the division's obligations to get permits issued in a timely manner, and then it goes on to talk about harm separately. So it doesn't equate the two right now, the way it's written. The division is looking for something broader that would encompass that type of situation, but others as well that maybe aren't even foreseen right now. So again, coming back to that concept of reasonableness. And unduly, unreasonable, and that's where we were trying to get with that term.
Maybe just one little additional point too. I think, we kind of have a death by 1,000 paper cut situation with our permit backlog. And so, what's another 30 days when somebody's already been waiting 3 years for their permit renewal? You can see how somebody could raise that argument, but we have so many permits that are backlogged that when you look at the sum total of everything, we really do have an obligation to keep things moving, and 30 days can make a really big difference in the number of permits we get out the door. So, to me, I guess harm is quite subjective. I think it is more subjective than unduly, in my opinion. And I think we're presenting ourselves with potentially more arguments about whether someone was harmed or not, and whether we made the right decision to, refuse to extend a comment period. And so, again, I think Annette's really summed this up well, but hopefully that helps a little bit.
Okay.
I have a question about what we're including. My recollection from reading these a couple of times is Exhibit 4 has a number of changes that are not included in Exhibit 5. So as we adopt this, we would be adopting it with revision 4, Exhibit 4, and the changes made to Exhibit 4 that are in Exhibit 5. Is that correct?
I believe that is correct.
Plus or minus the Baumgartner amendment?
Last call. All right. Thank you very much.
Thank you very much for your time.
Thank you.
So I think, do we have a motion to close the record? That what?
So moved.
Second.
So Rick and Joan. And now we deliberate. David?
So please, in addition to assuming good faith of all, and please assuming that there's a limit to when more information is beneficial. I actually went back and checked my administrative law because I don't think I did really well in it. But with regard to the division, there is something that's called a presumption of regularity. This has to do with time and undue delay of time, and and the presumption of regularity, it's a deferential scheme. It gives deference to the division's pace, for lack of better words. And that deferential scheme credits to the administrative agency procedural fairness, accountability, and attentiveness to assessing the complexity of the issues and the choices at stake. All of that is compressed in a presumption that they're cloaked with. So I think that takes care of whether delays are undue or not due. And it informs the fact that it is in their discretion. Discretion has all of those pieces in it. So if we say for that piece in D1A, that they have the discretion, and I think people were agreeing to it, to grant additional time, then what was it that we were hearing people were concerned with? On one hand, people were concerned that they have the opportunity to give to the decision maker information that might be beneficial to an informed decision. And a different concern was we have to get our job done in a reasonable period of time. So if we say all of those things, it's their discretion, and that they have to consider whether it's reasonable that the information they're going to get is going to lead to a better informed decision and not thwart them in their responsibilities or duties. However we craft those words, I think that's what everybody was asking for.
Okay. I think that was really well said. So to put a
couldn't do it again though.
To put a finer point on that, maybe, if I'm understanding you correctly, David, I feel like what may be getting lost in all of this discussion is that the commenter who requests additional time is going to be demonstrating the need for such time. So the division is going to be looking at the information that's submitted and making a decision, doing the balancing act that you said the words could say. But I think the words already suggest that the division is going to be doing that balancing act. They're going to be saying, they're going to be reading the argument that there should be an extended period, and they're going to be, balancing that argument with the need to continue moving forward with the process. So I feel like it's already here in the words that are being proposed by the division. I think, since unduly means unreasonable, there may be some benefit. I think people may have a better grasp of lack of reason than lack of due. It's kind of archaic. Undue is kind of an archaic term. So, but in any event, I think the demonstration that the person, the commenter, is going to be making is really where the rubber hits the road. And that's what the division is going to be focusing on to do the balancing, David, that you suggested they're going to be doing anyway.
I think having spent 2 hours on half a dozen words, I just want to make the comment that I think I don't want us to lose track of the bigger picture here of how far these changes in the regs have come. I think having an actual responsive comment period is a really big issue. When I first started negotiating permits, we did a lot of this before the public notice draft went out, which did limit transparency. There was a lot of back and forth with the permit writer before the permit was ever put out for public comment. So I think, and then there was the pendulum swang to, okay, the division doesn't talk to the permittee until the public notice draft. And I think this is a real balancing of the situation. I also can't help but note that the first permit renewal I ever worked on, we were in the 12th year of our 5-year permit. So I know permit backlogs. I agree with everything Joan and David have said. I do think that to the discharger who may not have an attorney or dozens of attorneys, unreasonable may mean more. And I do, again, I'm not trying to be facetious. I have signed hundreds of intergovernmental agreements, negotiated hundreds of intergovernmental agreements in my career that talk about, this or that will not be unreasonably withheld, or this or that will not be unreasonably delayed. So I think that's a term that I'm very comfortable in the legal documents that I've executed.
I think that unreasonable delay is probably more reasonable language.
You've been waiting all afternoon to say that, haven't you?
You're the third president.
So I would suggest that we keep the language that's been negotiated, but just instead of unduly delayed, say unreasonable delay. And in terms of the additional statement that the consolidated proposal suggests, I think with the Gusoff amendment that says these revisions are to ensure so forth and so on, is a reasonable addition to the statement of basis and purpose. I like reading statements of basis and purpose from the past because they give you the context of why did they do this. And I think this states that very well. So I would suggest that we insert that language into the basis and purpose language.
Just to, oh, sorry, go ahead. Oh, okay, I just want to make a quick point to sort of reinforce Rick's point that the beginning of that of 61.5 to D1A. Wow, feel like a lawyer now. Is there is this the second or the first full sentence is a comment period no longer than 30 days may be necessary to give commenters a reasonable opportunity. If we're not arguing about that reasonable, I'm not quite sure why we're arguing about unduly and whether reasonable could come in there. I just, again, not being a lawyer, I kind of wonder why we can be reasonable in one place and not be able to be reasonable in another place in this case. So, but I think I'm backing what you're suggesting, Rick.
Yeah, apparently we're jumping around between the two issues, the scope issue and the extension issue. So I don't know if you want to keep doing that. I wanted to piggyback on Rick's scope issue comment, but I don't know if we're there yet. I don't know how you want to manage it.
Why don't we see? Does anybody else have any more comments on the reasonable issue, at least until you start hearing more and think about it? Okay, let's move on then.
Okay, then to piggyback on what Rick said about the additional language as modified by Mike had suggested regarding the reason for the refinement to the rule about identifying issues. I'm really happy to hear that division supports that because I think it's good as well. I worried is too strong. I wonder if this change might discourage or exclude unsophisticated parties or general members of the public from, just kind of a notice pleading requirement, right? Just identifying broadly an issue and then having the division say, sorry, that's too broad. You should have raised it before. And I don't think that's the intent, but I think this clarification in the statement of basis, the statement of basis and purpose as modified by Mike is really helpful. So I'm happy the division is supportive of that too.
So the one question I have here is that I believe this revision as proposed, I'm just going to read it and tell me if I'm reading this as intended, Rick, but these revisions are to ensure that issues are brought to the division's attention early. So we're essentially saying the purpose. Because we're not, which goes back to, I think, what the division had a particular problem with. I'm not sure, and maybe I'm wrong, but do we want to ask them back up to discuss that? Because my understanding is that the joint stakeholders' initial proposal said the purpose of these revisions is to ensure, and it was revised to meet a division question that there could be other purposes. So they said, okay, we'll change it to a purpose. And now I think the way I understand this, we're going back to essentially this being the purpose. Or am I wrong? I just don't want to change something that we haven't actually gotten consensus on.
Kevin, what one suggestion? What if ensure is kind of, now I'm going to argue about a word, and ensure might be a bit of a strong word here. What if it is, I realize that we would like, ensure starts to sound like a guarantee that this is the only way we are going to bring these issues to the forefront or bring them up early. So what if it was, does it become too nebulous to replace ensure with encourage or something like that? I mean, the sentiment here, my understanding, is to try to get as much information to the forefront as possible prior to, as soon as possible. So in encourage maybe waters it down too much. I mean, but ensure also makes it sound like there's no other way we can do it, or this is the only way. So I don't know. I feel a little trapped there.
Yeah, and that's kind of, I think, at least my understanding, the balance of what this actual language is meant to do is just to say that, one of the purposes or a purpose is to ensure. That doesn't mean that there's not something else out there that would encourage. But I think, to me, encourage is probably a little too soft, because it's not, the intent of this is that, or at least I think, in an adjudicatory hearing, for the division to say, no, you can't bring up some new number over here that we never discussed earlier. So I guess I don't know either, and I'm bringing this up as a question of what we want to change here without talking to the parties.
So hearing all of you guys talk, it sounds like you don't want, you all understand that this is one purpose, not all of the purposes. So, I mean, one thing I would offer is, you said these revisions are to ensure that issues are brought to the division's attention. You could add these revisions are to ensure, amongst other purposes, comma, that issues or something, so that it's not a limited list.
Could you read that again? I'm sorry, I was blinded by the light. I don't know what I did.
I
originally.
Go ahead.
I think you're right, Kevin, that the division didn't like referring to this purpose like this was the sole purpose of doing this. So one of the things I had suggested originally is one purpose of these revisions. But yeah, we're getting down to arguing about words.
Yeah, and the reason I bring it up is because there seemed to be some reason that there was an intent to change it from the to
Well, rather than discuss the revisions, why not just state this as a goal? So in other words, the goal is to ensure that, or the intent. The goal is to ensure that the issues are brought to the division's attention early.
The quote could be, an intent is that issues are brought.
An intent.
An intent, we leave out of these revisions.
Okay.
An intent is that issues be brought to the division's attention early.
Yeah.
That is our intent.
That's true.
Anytime you can take words out, it's good.
Yeah. Jerry, you seem to.
Okay. I guess, does anybody else have?
Well, from a procedural perspective, we've been given two alternatives. We're coming up with a third, which maybe makes everybody unhappy, which I've learned with my kids is a reasonable way to move forward. Keeping everybody unhappy. I don't mean I guess that's just what we can do, and everyone lives with it, and we just move on from there. I mean, I suppose we've heard the input from what the intent was on both, in this case, both sides. And we're trying to find a middle ground without having really had that discussion with them as we go through this process. So, okay.
Yeah, I think we can ask. I mean, we can ask for their response if we want to. I don't know that it's necessary. I think, at least to me, they kind of both agree that this language is okay, not ideal for anyone, but or not necessary in one case, but okay, and necessary in another case, but could be a little bit different. So I don't know if anybody has an opinion about whether we need to ask for input.
Perhaps people will learn a lesson to leave it up to us.
I mean, does anybody feel strongly that either way, I guess?
I like David's suggestion.
I do too.
Okay. So it sounds like, I think I'll try to summarize. Yeah, so an intent is that issues interpreted broadly are brought to the division.
Sure.
Yeah, since we haven't discussed it at all, and I think that sounds like everybody's on board. I don't know.
Yeah, Kevin, I mean, the division didn't object to that parenthetical, which I was kind of waiting for, but I think it's important. I think it's a good way to sort of balance that issue that I raised, which is that non-sophisticated parties may not know they need to bring up, which species was used in a wet test. And that's just exemplary. The point is, I think there's got to be a little give and take on what the issues are. And that parenthetical will help, I think.
Okay, and I think on the other outstanding issue, basically we change unduly delay to unreasonably delay. So what we're looking at is Exhibit 5 as it modifies Exhibit 4 with changing unduly to unreasonably and adding to the statement of basis and purpose. Sorry, I'm not on. And adding an intent is that issues interpreted broadly are broad. So does anybody else have any, that's what I believe we're moving on.
So moved.
Second.
We'll go Rick and David. Barbara? Rick and then Barbara. Do you have it clear, Tricia?
I got it. Thank you.
So I think I'm done.
We have to vote.
Oh, yeah.
Oh, there's that detail.
Yeah. All right. So those in favor of basically what I said a few minutes ago, the motion, say aye.
Aye.
And those opposed? And the motion passes.
No, you can go back.
We are done. Thank you. Good job.
Good job, Kevin.